Welcome to today's broadcast of North Idaho College Public Forum. The crew is comprised of NIC television students, and your moderator is North Idaho College political scientist Tony Stewart.
Our subject today is one that involves all 50 states, and particularly the legislatures of each of those states, and that has to do with tort law. And there's many changes that are coming, and some call those tort reform, and others oppose the particular path that is taken. It is dealing with liability, and it covers all families in this country in many different ways, and it's so important that we decide to deal with the subject. It is also a major issue in the Idaho legislature during this session. To discuss this topic, I'm happy to welcome to the program two individuals who certainly are qualified to deal with the issue. First of all is Mike Verbillis, who is an attorney in the city of Coeur d'Alene, Idaho. And Mike, we're happy to have you with us. And we also want to welcome Spencer Dean, who is with Harris Dean Insurance Agency, and we hope to get the viewpoint of both the insurance company and the attorneys who often disagree. We're happy to welcome to our program also regular panelist, Coeur d'Alene attorney Janelle Burke, and she shall commence the questioning.
In order to set the stage for our viewers, Mr. Verbillis, could you please tell us what is the general concept behind what people call tort reform?
Well, to answer that question, I think I'd have to also first talk about what is tort law in general. Tort law, as a general principle, is the law dealing with violations of civil wrongs. We're not talking about criminal law. We're talking about accidents, things of that nature, where someone is deemed to be partially or fully responsible for an injury to person or property. That's the concept of tort law. The concept of tort reform is the notion that the legal principles surrounding the tort law that has existed for hundreds of years in the Anglo-American system should be changed. And there are various proposals around the country, and in particular in Idaho.
I think it's excellent that you started out by mentioning tort law in general. And would you please talk a little bit about intentional versus negligence so that our viewers understand that it doesn't necessarily have to be something that you intend to do?
Indeed. I think an easy illustration of the difference between intentional conduct and unintentional conduct is criminal activity that also gives rise to civil liability. For example, if a burglar comes into your home, he has committed a criminal act by stealing something, but at the same time he may also injure someone in the process. So you have an intentional act. He's intended the consequences of his act. Whereas if a person is driving an automobile and fails to yield at an intersection, they've done nothing wrong in a culpable sense, but they have breached a legal rule of the highway that you're supposed to pay attention on where you're going. You're supposed to obey the traffic lights. So that would be how I would describe the distinction between intentional wrong and unintentional wrong, or tort law, which is governed by the law of negligence.
And it is true that tort reform, so-called tort reform, would cover both the intentional and negligence aspects of torts.
Well, the provisions of the bill that cleared the House, House Bill 136, addresses both intentional torts as well as the general field of negligence.
And Mr. Dean, is this a movement that is nationwide, as Tony indicated, or is this something that is more of a local concern?
It certainly is nationwide, Janelle. The insurance carriers tell us that the reason it's so all important is that they have been recently, in the past few years, unable to predict the number or the size of claims, so that tort reform is needed to allow them to develop rates on an equitable basis.
Do you think that the problem is more severe in Idaho or less severe in Idaho?
It's my view that it's less severe in this state.
And why would that be?
We have a much lower population. Towns, cities are smaller, and that's basically it.
Now back to Mr. Verbillis. What are the specific provisions then of the Idaho proposed legislation?
Well, very briefly, the proposal of the bill that I referred to earlier would place a limit on non-economic loss in property damage and personal injury cases. It would abolish the so-called collateral source rule, which is a rule that basically deals with whether or not a person has health insurance. It would allow the jury to know about that, which traditionally it does not know. It changes dramatically, would change the concept of joint and several liability, which I'd like to talk to later on. It would mandate periodic payments for any judgment over a certain amount. It would immunize members of volunteer organizations, such as the Aryan Nations. It would require a double trial for any case wherein punitive damages is a topic, and it would lower the lawful rate on judgments from the current rate to a much lower rate.
Mike, let's just get into those because 30 minutes goes so fast, and I think we should get into the actual nitty-gritty of how the law would change, and we'll get Spencer to react to those and why, in many cases, I think the insurance company would support those. Let's just take one of those at a time, and in a, I guess, somewhat legal terminology, talk about how it is now and what you think the change would do to the whole area of tort law.
Well, I think in order to begin to answer that question, I think I'd have to say that the concept of tort reform presupposes that the system isn't functioning accurately. There is no data to support that view, and I have to say that at the outset. Basically, nothing's broken and nothing needs to be fixed. There is this frenzy that seems to have overtaken other parts of the country that seeks to change things. Specifically, speaking of non-economic loss, this law would place a limit, an absolute limit of $370,000 if a young child is crippled for life at the hands of a drunken driver. We find that to be unfair. If you want me to talk about these item by item, I'd be happy.
I would,
to.
in a brief and a simple way.
I'll be as brief as I can. The collateral source rule is a rule that says the jury is not supposed to know if you have health insurance. The reason for that is that every person's different. Some people have the resources to purchase insurance, or through their workplace, their employers provided it, and is considered not necessarily related to the lawsuit that a person happens to have insurance. It's served us well because in most cases, 95% of the cases, the portion of your award in an injury case that is related to that medical expense, let's say, has to be paid back to that casualty or health insurance company in any event. Our fear is that the abolition of collateral source will result in a double reduction by juries, and I've seen it happen in other situations. Abolition of joint and several liability.
Let's take one point at a time,
Okay.
if we can, and let Spencer react to that so we can see where the attorney and the insurance companies disagree. Why do the insurance companies want to make that change?
Well, of course, the insurance companies would like to see anything passed in order to, as I say, make the making of rates more predictable. I'm of the opinion, I pretty much agree with Mike that this one point is something that we probably should not do.
So this one you agree with?
Yes,
Mark?
I agree with him.
Fine. Mike, can we take the next point?
The Spencer mentioned rates, which is an interesting concept, and I'm sure anyone that's familiar with insurance companies can tell you that insurance rates historically have dealt with data based upon, this is what our life's experience tells us. They have big computers and they can predict, at least with mathematical precision, and what types of losses they will have and what areas of exposure. The companies in about the middle 70s and the early 80s quit doing that, and they went to a frenzy of rate competition so they could invest money in high-yield interest. AAA bonds, short-term money markets, that is what got the companies in the predicament that they're in now. It's just their investment decisions. But to answer your question and to go on, joint and several liability is really the cornerstone of tort law. It's the law that says that if a person is injured by more than one party, he is allowed to collect his full sum of injury or property damage, as the case may be, from all of the parties or any one of those parties that has contributed to cause him injury. Alteration of that principle is setting back tort law millennia. And I can expand upon that, and I can give you some specific examples if you'd like. If you can imagine a nuclear waste spill in Coeur d'Alene, Idaho, which in all likelihood will probably happen in our lifetime, if joint and several law is changed from its current posture, the trucker that has no insurance, who is perhaps 95% responsible for that wreck, will of course go on his merry way. The shipper, the company that has shipped the nuclear waste, will not have any exposure, whereas under current law they would have to pick up the whole damage. If we change the law, what will happen is the taxpayers will have to pick up that cost. That is one specific example of catastrophic loss that I can foresee happening if we change joint and several liability law.
Spencer, if I understand what Mike is saying, that would mean that if more than one is liable, but one just has maybe 5 or 10% of finance that can cover it, there is a loss. How does the insurance companies respond to the fact that you have to...
well, of course, and I don't entirely agree with what Mike is saying here, based on, well, to put it as simply as I can, that if, for example, if there was a manufacturer of a boat, let's say, just as an example, and that manufacturer uses 6 or 7 other firms to build the boat. The boat's sold, and there's a problem with it at a later date. The boat was sold by a local, let's say, a firm here in town who sells boats, and the manufacturer of the boat goes out of business. So a year or two later, there's a claim. Certainly, the individual that sold the boat, I don't feel, should be held responsible for 100% of the claim, because there's nowhere to go if the manufacturer is broke, if he's out of business. So I can see what Mike's saying. In some instances, there probably is a reason for the joint and several rule, but I think in many cases it's unfair to lay blame on one party who may not be responsible for the entire problem.
I would like to continue, but I want to let Janelle, maybe Janelle would like to take us through the other points. I her back in the program.
Mike, can you indicate to us what the next provision is, those of the essential provisions in the proposed Idaho law?
Well, we've spoken about 3 of the major points. The other major point would be a requirement, an absolute requirement for periodic payments on all judgments in property damage or personal injury claims in excess of $100,000. This would allow the insurance company to invest the injured party's money for the balance of his lifetime, or I believe the bill speaks in terms of 20-year increments. This, of course, is an abhorrent bill for this reason. If you have a person that has suffered a traumatic injury, an amputation or a severe neurological injury, and he is only allowed to get 5% of his award per year for the next 20 years, you've totally taken away the opportunity for advancements in medical science. If there is a cure that comes along for a certain disease or disabling condition, that injured person does not have the capital resources to avail himself of that cure. It also unfairly allows the companies, as I said, to invest the injured person's money. It's another effort to control perceived losses, but in an industry that has in excess of an $80 billion net worth, I have a hard time understanding the losses that they are claiming.
Mr. Dean, what is the rationale from the insurance company's point of view behind that change?
The rationale, of course, I think is that that in the long run, we all pay for these large claims, all of us. And if there's any method in which the insurance companies can pay claims over a long period of time, then of course that's a saving that all of us will realize.
Of course, in some structured settlements at this time, doesn't that occur? Mike, what is the present state of the law?
Well, I was going to mention that. The current state of the law is that the parties are free to contractually arrange for periodic payments, and I've done that in several cases. It's a practice that's widely done throughout the country. The difference is that you have to tailor a settlement to the particular needs of a family. If you have a family where the breadwinner is totally disabled or deceased, and you have a young mother with children, that is the type of case that you may look at to do periodic payments. But this bill would require periodic payments in all cases of any description of property damage or personal injury in excess of the targeted amount.
What are other critical provisions of the Idaho proposed legislation?
Well, I had mentioned earlier the immunization of volunteers in school boards, eleemosynary boards, elks, things of that nature. That sounds good on its face. I mean, everyone likes to think that they can join a volunteer organization and be free from litigation. The problem is that, like many of these types of laws, the pen is sweeping too broadly. Immunizing hate groups like the Aryan Nations is certainly not something that I believe the legislature intends to do, at the same time that they're considering legislation that would forbid them engaging in paramilitary exercises. So I just don't think the legislature's thought this one out very, very carefully. And you can't do it for just some volunteer organizations and not for all of them. So that's my main opposition to it. I believe that responsible volunteer civic organizations, in order to remain responsible, need to know that they do indeed have responsibility. Volunteerism, which has been a theme of the Reagan administration, is not to be discouraged. But by the same token, it implies a certain degree of putting your person into it, and that person includes your responsibility as a human being for other people.
Mr. Dean, would you tend to agree on that point?
I would tend to agree on that point. I think whether it's a volunteer or whoever it is, if you commit a tort act, if you cause injury or something, that you should be held responsible for it.
Recognizing, of course, that as our conversation has developed here, we've talked about some groups that might intentionally take actions, but that there could also be actions that might result in property or personal damage that were not in any way intentional on the part of a volunteer group, simply a misjudgment. Are some of these covered under other laws as well?
Well, there is case law that immunizes volunteer members, and one of the
under certain circumstances.
Under a wide variety of circumstances, and there are other proposals that I think will be introduced or are under consideration in the Senate at this time that would have the tendency of chilling specious lawsuits. In other words, lawsuits that are groundless. We support legislation that would give the court the power to award costs against the attorney that brings a groundless action, so that if a volunteer, for example, is brought into a lawsuit that he has no business in being in, the attorney better look at his whole card before he files such a lawsuit. I think that's a very sensible approach. A moment ago, Spencer talked in terms of large claims, and I had to come back to that. I hope you'll allow me. This notion of claims and losses in Idaho is something that needs to be talked about. Last year, the 1986 legislature passed a prototype reporting act, or reporting bill. It's very similar to the one that passed in Washington 2 years ago. And it requires the casualty and liability companies that write insurance in Idaho to give statistical data based upon how much money they collect, how much money they pay out, how much they pay their defense lawyers, and how much the people get. Because one thing that we have to talk about in this whole debate is the people. Tort law isn't about lawyers, it's not about insurance companies, it's about people. Anyway, getting back to the Reporting Act, the data is not yet in. And back to my earlier theme, until we know if Idaho has a problem, I don't think we should be increasing our rates or altering a tort system based upon experience in other states. And I think that's exactly what the companies have done. We do not have data on Idaho loss experience.
I would like to pursue one point because it has impact on other legislation. there is a bill moving through the legislature called the Civil Remedies provision concerning if one is, in a very intentional way, harassed or affected because of their race, religion, national origin, and so forth, that they can bring civil suit. And they can do it for actual damages, they can do it for punitive damages, and even attorney fees. If that bill comes in, it becomes law, and it comes into conflict with the change in the tort law, is it possible we start dealing with a constitutional right in question here? Can these statutes be challenged, particularly the tort one, from the Constitution? Don't you have some, if you have another piece of legislation, don't you have some basic right to sue when you can prove that this harassment's coming because of the race that you belong to?
Well, I think I understand your question. Not only does tort reform not make sense, but it is also, in my judgment, unconstitutional. We have constitutional provisions in the state constitution as well as the federal that guarantee every citizen equal access to the courts and a sure and speedy remedy for every wrong. So what you're illustrating is a conflict between one part of the body politic of Idaho that needs to be served and running head on with this tort reform business.
Spencer, are the insurance companies beginning to look at this? Is there any possibility of accommodating these possible problems that could arise that would also require additional litigation?
Yeah, it's my view that I would prefer to see tort reform on a national level. What you've got right now is tort reform procedures, things changing in all of the states, and I think what we're going to wind up with is a hodgepodge of problems. And I think that if tort reform makes sense, and I'm not sure that it does, that it would be better served if it was done on a national level.
I guess I want to get to a bottom line for both of them and give both of you an opportunity to deal with this. We hear very different stories or information coming from the two sides. We hear an awful lot of effective campaigning going on that insurance companies are really in trouble financially and they're not making money, or as much as they did in the 70s. As we hear that, Spencer, we'll let you answer first, that it's put forth that there are a lot of large lawsuits being won for $1 million, $2 million, or $3 million. And the most recent example that you hear insurance companies put out was the lady who, after x-rays, won $1 million suit because she lost her clairvoyance. How much validity is there to the information that insurance companies are in deep trouble or are losing a lot of their capital?
Well, I don't think that there's much truth to that statement, that insurance companies are losing money. I was just telling Mike a couple hours ago that I just, in the Wall Street Journal, the February issue of the Wall Street Journal, fourth quarter results for the insurance industry are in, and the industry made $1,287,000,000 for the fourth quarter in 1986, having turned it around from 1985. There are some reasons why the insurance industry got in trouble in the early 1980s, but this was more or less a response to the market conditions. High interest rates, there was a soft market at the time, and those two factors combined tend to make that soft market last much longer than it normally would. The industry has always fluctuated as far as the availability of insurance and pricing. And when companies make money, they tend to go out and hire new agents. They expand and prices come down. What happened in this case, of course, was that it just lasted too long, and the insurance companies didn't get it turned around in time. And by the time they did, they had a real problem on their hands.
Mike, from the viewpoint of the attorneys or the American Bar Association in particular, how do you respond to the examples that come forth? And I know you have some statistics that you probably would like to quote, but are there a lot of cases where there are very, very large awarding of funds to the plaintiff in cases that some would contend was too high award?
I don't believe so. And in fact, what happens is if some lawyer turns his typewriter loose somewhere in the corner of the country and sues for X million dollars, that gets reported in the media. that gets later turned into copy somewhere in someone's newsroom. There have been verdicts, and there have been large verdicts around the country, and there have been some that, by the way the story is drawn, look to be a little wacky. There are no stories like that in the state of Idaho. There have been 5 7-figure verdicts in the state of Idaho since statehood. One of those was a recent case where a worker lost his dominant hand. And of all the 7-figure verdicts I'm aware of, even in this part of the world, or this part of the country, shall I say, most of them involve paralysis, amputation, or brain damage. So I don't think that there is a problem with verdicts. There is a problem with investment decisions made by insurance companies. And I think Spencer hit on that a little bit. But right now the playing field is fairly level. And I don't think it's fair to tilt the playing field to make up for bad business judgments that insurance companies made in the latter part of the 70s and the early 80s.
It appears to me, and you can correct me if I am wrong, that we're dealing with such a very, very complex area of law. And Spencer alluded to this earlier. Does it make sense to draw back and to take a look at this whole problem, not suggesting that there shouldn't be any revision at all in law, but should we take a look? Mike, would you agree with Spencer that maybe we should take a look at some kind of national legislation, but on a somewhat different path? I'm speaking to the fact that I know that there's some states are looking at a very different approach than what Idaho is when they deal with some new legislation on oversight and reporting of assets and liabilities, and also creation of some state pools for local governments if insurance companies choose not to insure them. Should we take a look at that?
Is that for me?
Yes.
Well, there is a bill in the legislature to create a state pool for the state, the cities, counties, and for industries that cannot afford insurance. That bill, as I understand it, it was in trouble last year. It didn't get out of the Senate, and it's in trouble this year. About 20 states have already done this. And in some states where they've adopted state pools, they have restored competition into the private sector. One of the states back east, I can't remember if it's Massachusetts or Vermont, did adopt a state pool, and then within a year, a private company went in and underbid the state. So to answer your question, yes, state pools for state and county units of government is a possible solution. Overseeing of the way insurance companies handle money, just as we do banks, for example, is an approach in the right direction.
I'm sorry to interrupt. I wish we could go on and ask a lot more questions, but we're out of time. And on behalf of the staff and Janelle, we thank you both. You were very thoughtful and cooperative to be here with us on this important subject. Ladies and gentlemen, I hope you've enjoyed our program and that you'll be with us again next week. Until then, please have a good week. I am Tony Stewart.
North Idaho College Public Forum can be seen at the same time each week over this station. This production was videotaped earlier by an NIC student crew for viewing at this more appropriate time.